Yes, I'll quickly jump into the outline of the presentation today. Uh, First, we'll be looking at some terms explained, the jargons which will repeatedly come across. Then we go into the problem, the introduction, why this, how this thought occurred. Uh, I'll briefly go into what Section 31A is and cover subsequently the literature, the theoretical and comparative framework around 31A and costs. Prashant, after that, will take over and dive deep into research objectives, the methodologies, and the findings of our uh, research, and will conclude with the stakeholder visions for reforms. So jumping right into the terms explained, at first, we have what is cost imposition or allocation. Essentially is the decision taken by a court or a tribunal about which party ultimately bears the litigation or the arbitration expenses. Essentially, who will bear the costs or the expenses to a dispute. The next term which you will see recurring is loser pays rule or cost follows the event. This emanates from the British rule or originated from British or England. The rule is essentially that the side which loses normally has to reimburse the winner's cost. Quantum of costs, the amount of money the court or tribunal ultimately orders after its determination on one side, which has to pay. Indemnity costs, full reimbursement of legal expenses reasonably made in relation to the dispute. Discretion, the legal freedom judges or arbitrators have to decide how much, if, how much, and when to award costs. Frivolous or vexatious claim, a weak or an abusive case filed mainly to harass or delay. Cost schedule or bill of costs, a detailed list showing each expense item that the winning party asked to be reimbursed for. And finally, zero cost order, the decision that leaves each side to bear its own expenses, where there is effectively no shifting of costs at all. So with that, I'm moving on to the problem, or the introduction of the problem. I would like to bring all of your attention to this interesting case. The judgment was passed in January 2024 by the Bombay High Court. Rachna Kamlesh versus Sunshine Financial Services. A Section 11 application was filed for the appointment of an arbitrator by Rachna Kamlesh. But interestingly, there was no concluded contract between the parties. There was no signed arbitration clause or an agreement. Noticing this interesting fact, the judge held that this application itself is not maintainable because there is no arbitration clause, or for that matter, concluded a contract between them, and dismissed it. But interestingly, the judge still ordered no costs on the applicant, despite Section 31 existing. So what happened as a result of it? The opposition, that is the party which was dragged into the court, is burdened with the costs of conducting this litigation, and the frivolous instigator went untouched and scot-free. So this is a trend which we will see throughout this presentation and throughout the paper, a frivolous claim with no consequences. Let's have this thought in mind, and then now I'm going to explain what 31A is. 31A is the specific section within the Arbitration and the Conciliation Act 1996, which was introduced in 2015 by way of amendment. I will go into the evolution of it, but to give a brief background, the 246th Law Commission report, which gave a lot of sweeping recommendations for the change of arbitration practice, also recommended Section 31A. So what does Section 31A do? What does it empower? It empowers or grants arbitral tribunals and courts the discretion to impose and allocate costs in arbitration-related matters, not just in arbitration, but also arbitration-related litigation by courts, which appear before courts. So what is costs under Section 31A? Reasonable fees and legal expenses of the arbitrators or any associated dispute, meaning the litigation. So how should the cost be imposed? What is the default rule? The default rule given under Section 31A is cost follows the event, or the loser pays principle, which I had discussed a little while ago, in which it means that the loser party ordinarily pays. And the section also provides that if there is any departure from this general rule, then it must be explained in the arbitral award or in the order. The section also has a discretionary checklist to determine quantum of the cost. This checklist includes the conduct of party, the degree of success of the party, how many claims was won between them, and the nature, frivolous nature of the claims and defenses, and if any settlement offers were made by any of these parties. Ultimately, like in everything associated with arbitration, there is also a scope for party autonomy. That is, if parties have decided amongst themselves that the costs will be apportioned between them in a particular manner, Section 31A will stay out of it, or rather the courts and the tribunals will stay out of it. But this decision has to be made prior post the dispute has started. So quickly going over to the theoretical and comparative framework. This is essentially, there are multiple models which are followed across the globe. So this is the highlight of 3 of such models. First is the American rule. Each party pays its own litigation fee and costs regardless of outcomes. A versus B, even if A wins the case, B is not obligated or imposed with the cost burden to cover A's expense. Moving on to the English one, the losing party pays the winning party reasonable legal costs. What is the intention behind it? To make the winner whole and with the purpose of discouraging weaker claims or litigation. Then there is a third one, the hybrid model, which is a proportionate cost allocation, which is based on the degree of success achieved by a party. Assuming that a claim has 10 issues, if party A wins 6 claims and party B wins 4, the cost will be allocated proportionately, proportionate to the 6:4 ratio. This is more closely aligned with the actual outcomes. The hybrid model is a more recent development compared to the American and the more established American and the English. So what was the situation in Indian litigation? Now we are looking, I want to take you to Indian litigation before we go specifically focusing on arbitration related litigation. What was the cost shifting or cost allocation patterns, trends before 31A existed? It was seldom enforced. So if you look at Arbitration Act itself, there was Section 31(1)(8) prior to the amendment, which only said arbitral tribunals could impose costs with no real guidelines or any clarity as to what is to be followed, what is the principle to be followed. Now, if you look at courts, courts could allocate litigation costs under Section 35A, 35, and 35B. Now, speaking specifically about how frequently and consistently this was imposed, it is important to draw your attention to Salem Advocates Bar Association. This case is very critical into this discussion because this was the case which inspired the 246th Law Commission report to recommend Section 31A in the first place. What did the judgment say? The essence was very simple. It criticized the practice of not imposing costs and observed that this is encouraging frivolous suits and defenses. It urged courts to award actual and reasonable costs. In 2012, there was a Law Commission report, the 240th Law Commission report, which looked exclusively on costs, which repeated pretty much the same thing. Costs are unpredictable and unreasoned, and even frivolous claims got no costs or token sums. There was no coherent standard across family, tax, land acquisition, or even commercial disputes. So what we see here is a judicial reluctance before 31A was brought in. We are looking at judicial reluctance at the level of courts. An empirical study of 83 SLPs before the Supreme Court with relation to arbitral appointments by Badrinath, uh, observed that only one case, cost was only imposed in one case, despite the high litigation cost. Now, taking an amalgamation of all of this, it was distilled in the 246th Law Commission report, where it was recognized that arbitration involves high procedural costs, and so does arbitration-related litigation. So the recommendation was very straightforward. Adopt a robust loser pays regime, empowering the tribunals and courts to award realistic and success-based costs and spell out the rules early with the purpose of deterring frivolous arbitration and litigation. So here, I want to take your attention to this flow chart, which is essentially showing you how to interpret Section 31A. Why this is important is because we have identified that there are three levels of discretion, which is important to understand the effectiveness of Section 31A. The first level of discretion is to decide whether cost has to be imposed or not. Despite the Law Commission saying that we need a robust regime on Section 31A, there is a first level of discretion given to the courts and tribunals to decide whether cost has to be imposed in any of these cases. The next level of discretion is only active if the first level of discretion is exercised and decided that cost has to be imposed. To that, there is no duty on the courts or the tribunal to give an explanation as to why they have decided not to impose costs. Once the first level of discretion is open and it is decided that yes, we will impose cost, we'll come to the second level of discretion, which is the default rule. Loser pays principle or not loser pays principle. Deviation requires written answers, written reasons. And level 3 includes the factors to be considered for the quantum or allocation. What is the practical effect of these three tiers of discretion? It essentially results in zero cost inertia and effectively undercuts the statute's intent. So what we see here is there existed a problem. There is a statute which was brought on, but is full of loopholes. And I bring your attention to this particular case, which was decided not regarding arbitration, but regarding commercial disputes, where the Supreme Court has said, and I'm quoting the judgment, there seems to be often a hesitancy in our judicial system to impose costs, presuming as if it is a reflection on the council. This is not the correct approach. In a tussle for enforcement of rights against a state, different principle applies, but in commercial matters, costs must follow the costs. The judgment goes on to re-emphasize three principles: loser pays a default, market-aligned quantification of the costs, and to reduce abuse through deterrence, that is through cost sanctions. Now, there are two studies which happened post the introduction of Section 31A, specifically looking at whether costs have been imposed by the Supreme Court. In the first study by Dharmendra Chatur, he has looked at the Supreme Court's appointment, Section 11 appointment matters for 10 years, for 9 years, and has observed not one case where cost has been imposed. Badrinath, in his 2017 paper, looked at one case from three different courts and found that despite there being reasons, the court has not imposed costs. So what we see here in the existing literature is that there is a concentration around Supreme Court decision. There is examination of that, but doesn't give a clear picture about how cost is imposed for domestic arbitration, because Supreme Court appointment orders are mainly for international commercial arbitration. Also, the studies have not gone into high court practices, which is a clear reflection of domestic arbitration matters. Secondly, and most importantly, the reason why there is a reluctance has not been recorded in any existing studies. So setting the stage now, I'm handing over to Prashant, who will take you through the research objectives and the subsequent portions.
Thanks, Vishnu. Hi, everyone. So, when we took up this study, we decided on these research objectives. Number one, how often does cost shifting occur in high courts? And we picked up Bombay High Court for this. Why do so few benches impose costs? What triggers a cost order? Is this consistent? And what reasons do judges give or not give to justify their cost decisions? We know that, arbitration awards maybe sometimes, you can access them through high court judgments because the judgments refer to them. But otherwise, arbitration awards or the proceedings are not accessible. So it's very difficult to know actually whether costs are being imposed or not being imposed. And so that information is not available. So we had to then limit this study to arbitration related judgments or proceedings, and we couldn't focus on arbitration awards or arbitration proceedings itself. So we picked up Bombay High Court. The quantum was manageable. Delhi High Court, as we know, there's a large number of cases. So we assessed frequency, quantum, and reasoning of cost. We picked up for 2 years, 23, 24, and we picked up sections 11, 34, and 37. 34, 37 are, judicial review and appeals. Section 11 is about appointment. We did a method study. So we did both quantitative and qualitative. So we analyzed the judgments using manual coding, and we extracted the data for how many cases actually involved cost impositions. And for qualitative, we conducted 36 semi-structured interviews. This was part of a larger project, and 22 stakeholders also shared their insight on costs. This included lawyers, retired judges, tribunal representatives, institutional representatives, and some in-house counsels as well. We integrated the findings to identify alignment or divergence, whatever the case may be, between doctrine and practice. Okay, then the judgment collection was done with the help of Manupatra and SSC online for relevant judgments for orders. For qualitative analysis, we explored the cost awarding practices, deterrence failures. So we asked those sort of questions to the stakeholders. Why do they, if they award cost or if the cost was imposed in their matters, why not? 2 researchers did independently double coding for transparency and then reconcile the differences. We, of course, asked for consent, anonymize the data, and the data is, in a password protected file in a shareholder with only 2 researchers having access to it. We manually extracted the cost award patterns, and for qualitative, even for quantitative, we did one more research, which was conduct-based trigger analysis, which is basically a study of false negatives. So judgments where we think that misconduct was present and yet the judge does not impose any cost. So we used LLM to highlight and flag, identify if there was misconduct and whether cost was imposed or not. And this was validated with human intervention as well. Now, limitations of this study was that this is single jurisdiction. We wanted to study high courts, but we could pick only one high court. We didn't look at other high courts. The judgment sample is from 2 years data. So only 23, 24, and it had 102 cases. We picked all cases. It was not a sample. It was all the cases in those 2 years. Stakeholder diversity, we reached out to, and we tried to reach out to all stakeholders relevant. However, we couldn't interview any, especially government in-house counsel and sitting judges. So these 2 stakeholders, our outreach was limited. As I said, we couldn't do study arbitral awards or arbitral proceedings because these are not available in public domain. 2 hypotheses we came up with. First is that cost orders are issued in less than 5% of Section 11 and 34 cases. And hypothesis 2, even where misconduct is present, the court does not impose cost in at least 90% of such cases. So here is what we found. We find that out of 102 cases, only 4 cases, the judges had imposed costs, which means it's less than 4%. There were 43 benches, but only 4 benches imposed cost. But actually, these benches also are not very consistent in imposing cost. Sometimes they do and sometimes they don't. So which means that most litigants leave court without any cost orders. Section 11 matters usually, do not involve costs as much as Section 34. So Section 34 matters are more likely to be imposed with costs. And what Vishnu also spoke about, which is that 31A has an inherent design flaw, that it grants broad discretion, but there is no obligation to award costs. So its silence is easy in the sense that judge doesn't have to give any reasons. There will be no appeals, less drafting. So it's zero cost inertia, right? Only if they decide to impose cost, then they may have to give reasons if they choose to deviate from the default principle, which is loser pays principle. But otherwise, they don't have to give any justification if they decide not to impose costs. And then in the law, of course, there are general factors listed, but there are no benchmarks or standards, and it's discretion without much guidance. There is some guidance, but the principles are not clear as to how to determine costs. So one stakeholder, and this is a retired judge, who say that they scratch each other's backs, trying to be a nice person. We don't need to impose cost. If you impose cost, there'll be red faces all over, and they'll talk about party autonomy. So judges are risk averse. They want to avoid cost to prevent perceptions of punishment. They don't want friction with the bar. They want to steer clear of political or reputational risks, especially, if the disputes involve government parties, and actually half of these cases involve government parties. The other thing is about post-retirement careers. So, cost orders may affect future arbitrator appointments, because the retired judges who are currently in the court, they will be retired soon. And then, they may also take up arbitration as their future career. And so these cost orders will create a perception of very harsh judges or strict judges, and it may have an impact on their career. So here is another retired judge who said, punitive costs are rarely imposed, and arbitrators often seeking future employment or appointments hesitate to appear strict. This is also true for arbitrators, because arbitrators also thrive on repeat appointments. And so they don't want to appear to be very strict to parties. So what triggers a cost order? And, these are the 4 cases where costs were imposed. And if you look at the reasoning, right? So there was, in one case, it is deliberate attempt by parties to derail arbitration. In the other, it is taking a chance with litigation by appealing an articulate and sound decision. In the other one, the appeal was time barred. And in the 4th one, the arbitral award was branded patently illegal and perverse. So either these appeals these challenges were very meritless, or there was some sort of procedural abuse by the party. And so these are the cases where costs are imposed. Now, to be very clear, 31A has both principles, both objectives. One is indemnity and one is punitive. But in all these 4 cases, it's mainly the punitive objective which is highlighted. I mean, courts are imposing cost when they see a procedural abuse or a frivolous or meritless claim. So costs are triggered by misconduct and not mere losing. So they are rarely imposed cost unless there is flagrant abuse or frivolous claim, and default remains that each party bears own costs. Okay. So another stakeholder say that I don't see courts awarding costs that much, even in opposing enforcement of foreign awards. There is one case, Vijay Carrier case, where Supreme Court had imposed cost of 50 lakhs, but that was an outlier. So costs are punitive. They are not compensatory. They are not indemnity based. It's important for the adjudicator to appear neutral, then to hold lawyers or parties accountable. Misconduct is a necessary, but appears to be an insufficient trigger, because it's not that in all cases that involve misconduct, they impose cost. Okay. So this is occasional disciplinary tool, but not routine or predictable mechanism for compensating success. Now here is the false negative analysis. We found 60 cases where courts had identified misconduct and no costs were awarded in 56 cases. So only 4 cases costs were awarded, but 56 cases there was either misconduct or some sort of meritless. And it's not that this is our judgment. We totally went by the court's observations in the ruling, in the judgment. Right. Now, the consequences are, of course, this would undermine predictability. The council will not be able to have any clear guidance, and it reduces 31A to occasional discipline. Or I would say, it basically means some few outliers which are there. Now we look at quality of reasoning and engagement with Section 31A. So out of 4 cases, only in 2 cases, there is some reasoning. 2 judgments give just one-line orders with no reference to Section 31A, no discussion why cost is being awarded, or no reasoning as to how they are calculating it. But in 2 cases, it talks about, they actually ask for bill of cost from the parties and they award cost. So in the remaining 2 cases, the cost was symbolic and it was not reflective of actual expenses. So why there is, failure of 31A? Why Section 31A underperforms? We call it culture of cost avoidance. So as we see that there are only 4 published cost orders in last 2 years, which means less than 4%. And judgments. I mean, it's not that there were no judgments. There were judgments worthy of imposing cost, but in 56, there was no cost imposed. So what are the consequences? Consequences are that lawyers will still see litigation as low-cost gambit, and winning party, expect to absorb their own cost. So indemnity principle is absolutely ignored, because even in those 4 cases where they actually imposed cost, it was not based on indemnity. It was mostly based on, it was triggered by punitive reasons, although they did ask for bill of cost, but it was not fully reflective of costs. Now, when we reached out to stakeholders and asked for, what they think, should there be reforms and what reforms? And here is what we also looked at TK Vishwanathan committee, which is 2024 committee. The report was out in 2024. And the committee also noted that there should be move towards mandatory indemnity. There should be no discretion. Quantum should be proportionate. In fact, if you want to, give the flexibility to the judge, the flexibility should be to the extent that if the judge doesn't want to impose cost, then they should give reasons. So it should be reasoned order for not awarding cost rather than, zero cost inertia. There should be bifurcated cost decisions. So international tribunals, for example, ICC and other places, international arbitration tribunals, they usually have a separate hearing and they have a separate cost order. So they ask both parties to submit their cost of bills, and they have a separate hearing to decide on the quantum of costs. Okay. So we conclude, on our conclusion is that Section 31A, it is rather symbolic because costs are rare, and it's because of the discretion vested in the judge that the promise remains unrealized. And the reform imperatives is, what I just discussed, that there should be default rule to impose cost coupled with mandatory written reason for zero cost orders. One retired judge gave another very interesting reform idea, which is to introduce wasted cost regime, which is there in the United Kingdom, which means that the lawyers are personally held liable for negligent and dilatory conduct. So that's another interesting idea which we think should become part of the Indian regime. Yeah. With that, thank you so much, and we are open to questions.